Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. I receive many inquiries about how to receive an employment authorization in the United States. And I have to disappoint you. Not everyone can qualify for an employment authorization. Usually, employment authorization is given to somebody who is on a way for their green card or has a special status in the United States. For example, a very common category for an employment authorization would be C9. C9 means that the person is in the process of applying for adjustment of status. And it's usually adjustment of status under Section 245. Those who are applying for adjustment of status based on asylum status after they've been an asylee for a year would not be able to receive a C9 employment authorization. To be honest, they don't need one now also, because when you're an asylee, you're allowed to work in the United States without any restrictions. Another common category for employment authorizations would be C8. C8 category. C8 category is assigned to those who are waiting for the asylum application to be decided, whether they're waiting in court or in asylum office without being referred to court yet. An interesting point here: if a person's removal proceedings are administratively closed and the person was an applicant for asylum application was filed, the person is still eligible to receive employment authorization based on that pending asylum application, even though removal proceedings are administratively closed. Not terminated, but administratively closed. Another interesting situation is when somebody is a VAWA applicant. A VAWA applicant actually may qualify for an employment authorization under three different categories. First of all, very often VAWA applicants are also applying at the same time for adjustment of status, and they will be able to receive C9 adjustment of status. C9 category employment authorization. They also can qualify for, I believe, C14 category. Nowadays, the VAWA application actually asks you, if you're in the United States and would like to receive an employment authorization, would you like it? And it automatically is going to come to the person who has an approved petition, if the petition is approved. And also, so no separate form I-765 is needed. And also there is one more category, is for those who are granted deferred action. So a VAWA applicant sometimes can get various employment authorizations based on specific various grounds. Sometimes though it's wise to use one of those grounds depending on the person's situation. Often a VAWA applicant and VAWA beneficiary will not be able to receive adjustment of status, hence they will not be able to get a C9 employment authorization. But they might have employment authorizations available for them on other grounds. So those are the most common categories for employment authorizations, codes for employment authorizations in the United States. There is one more category, is A5. It is for those who received asylum status in the United States. Interestingly, asylum status, a grant of asylum in the United States, is not an admission held by many courts, but it's a separate topic. What was interesting about this A5 category, as I told you before, often the person does not need an asylee, in fact, does not need a special proof that they can work in the United States, but sometimes the person does not have any other way to show that he or she is in legal status in the United States, and without this employment authorization they will not be able to find a job or will not be able to get driver's license, and that's why they're applying for this A5 category. So those are the most common categories for employment authorization. You can actually learn more, if you'd like to, on government website www.uscis.gov, and the application form for Employment Authorization is Form I-765, and in the instructions to the form, this is where you can learn about different codes and different grounds for employment authorization in the United States. Thank you.